Good morning, Your Honors.
Yes, sir.
I am Brian Ward. I represent appellants who are the defendants in the circuit court, an investment advisory firm, IAP, and its CEO and Chief Compliance Officer, Joe Franklin. We're appealing the trial court's denial of their petition under the Tennessee Public Participation Act, or TPPA, of a defamation and libel case brought by a group of the firm's departing advisors that was based on a required regulatory filing that defendants had made.
Do you want to reserve any of your time for rebuttal, sir?
Yes, 3 minutes.
3 minutes.
I believe they've been reserved. Thank you.
Okay. Then you may proceed. Go right ahead.
Thank you. So what are the underlying facts here? Well, in April of 2020, defendant Joe Franklin found out that plaintiffs wanted to leave defendant IAP, and during that transition, duly registered with another firm. After consulting with its outside compliance consultant, Mr. Franklin told them they couldn't do so. They did so anyway. So in June of 2020, IAP became aware that this had happened, that they had registered with another firm. Defendants decided to terminate plaintiffs, and as required by FINRA and the SEC, they filed Form U5s. Those are the disclosures at issue. Actually, the subsequent ones were, these noted that in good faith, but incorrectly, that the terminations had been voluntary. Those are not at issue. What has been placed at issue in the complaint here are the amendments to these U5s in January of 2021. And in those U5s, also required by FINRA and the SEC, they noted evidence that they had found of misrepresentation, misuse of customer information, and selling away. That's a practice where a client engages in unauthorized outside business activities. And that's came up as part of their ongoing investigation. They changed the termination from voluntary to involuntary. So
the main issue here is that I'm asking the changing of the termination from voluntary to involuntary.
Actually, Your Honor, that's a complete red herring in this case. The change in there was no harm alleged from the initial disclosure of voluntary termination. And in fact, the verified complaint states on page 4, paragraph 19, quote, defendants initially accurately stated on plaintiff's U5s that plaintiff's termination of their affiliation with IAP was voluntary. And now in their appellate SIR reply, plaintiffs have taken a contrary position to say that this was, quote, prematurely and falsely reported as a voluntary separation. But whether or not that was correct in the first part to be voluntary is irrelevant here because there's no harm from that. That's not part of there are no claims made in their complaint based on that coding of being voluntary. All the claims are based on the subsequent amendment, which changed it to being an involuntary termination and mentioned these 3 bases that they had originally suspected, as they say in the actual language of the amendment. And it says that these are allegations in there. And it says in the language, the amended reasons for termination were initially suspected, but not certain. Ongoing investigation has provided confirmation, and the full scope has not yet been determined. So there's also some dispute in the briefing as to whether this was the statement was a notice of allegations that were being investigated or the statements of fact. That was the clarification they made, which was right there in the document itself, that these were allegations and that there was an ongoing investigation, that these were initially suspected, these 3 bases, these 3 violations that they had were initially suspected, but later confirmed. And that's all consistent with actually what the firm found and what's in the evidence. And there was some discussion about whether or not we had called these allegations in the briefing, and we had both in our initial brief. We did so at page 8, 12, and 13, 15, 16, and 17. And in the circuit court briefing, we did as well. The TR 547, we said they truthfully reported an investigation into allegations. So after plaintiffs filed this case based on libel and defamation, and defendants filed a petition to dismiss based on the TPPA. The TPPA has a three-step process. This is a 2019 statute, so it's a fairly recent construct, but it has under 2017-105 a three-step process. And as applied, the circuit court found under the first step that defendants, my clients, had established their prima facie case. The case related to the court found the case related to defendants' exercise of the right of free speech. So then, under the TPPA, they go to the second step. The court found that plaintiffs had met their burden under that step, establishing a prima facie case that defendants had knowingly published false statements. And we have appealed that as part of the decision. The circuit court then simply ended its analysis. It failed to even address the third step, which is under Section 105. Whether defendants had established valid defenses, and we appeal this error. So under the first step, the circuit court correctly found that defendants had met the first prong. They had established their prima facie case, the case related to defendants' exercise of the right of free speech. This makes sense. This is a required regulatory filing upon any termination within the industry. And the fact, and in fact, plaintiffs don't even dispute the defendant's speech implicates a matter of public concern. In their opposition to our TPPA petition, they wrote, quote, plaintiffs do not dispute the defendant's statements in the Form U5s, if they were true, would be a matter of public concern. So where plaintiffs have taken issue with defendants and the circuit court is where the circuit is in attempting to add an additional truth requirement within this prima facie case on this first step. And to begin with, the disclosures were true, which I'll get into in a second. But regardless, truth is not a requirement under this first prima facie step. The TPPA itself says it's going to be construed broadly to affect its purposes and intent. And in the Doe against Roe case that we've cited, the Tennessee courts have already said that this statutory language makes clear that matters of public concern are broadly defined under the statute. The legislator wanted to limit matters of public concern only to those that were factually true. It could have done so. It didn't do so. And in fact, establishing in a prima facie case as requiring truth would bring in all three steps into the very first step of the TPPA, which wouldn't make sense. And again, the Doe against Roe case that we cited found expressly against that the exercise of free speech comes within the purview of the TPPA without engaging in analysis as to whether such speech may have been made with malice. So that's for later steps. So then in step two, the circuit court erroneously found that plaintiffs had met the second prong of the TPPA. And I won't go into their analysis at this point, but I will say that the circuit court failed completely to address the knowing falsehood essential element of defamation. In other words, the part of the four elements that needed to be proven, or at least a prima facie case put up, is that there was a falsehood, but also that it was knowing, that the defendants knew what they were doing, knew they were making false statements.
Wasn't there evidence in the record presented that Mr. Franklin told a consultant, Pragnell is continuing to fight us moving forward. We will need to list reasons to terminate for cause via the operating agreement. If we continue to get pushback, we will look to amend his U5 to terminating for cause. Is that not evidence enough to show that this was done with an ill motive from them not cooperating in the way they're leaving?
It does go towards motive, but motive is different from malice, which requires a knowing understanding that there is something false to be filed. So this is going towards whether or not to file something, but not towards his belief as anything that was going to be filed was going to be false. And in fact, if you look at the record, you can see that he had ample reasons to make each of those three concerns. With respect to violations of client privacy rights and misrepresentations, there were signed documents approving the release of their customers' confidential information under the cover of being an authorized signer for IAP after the plaintiffs had been terminated. There was evidence that they had falsely represented they had received authorization from all their customers, They also ran reports to obtain information about customer accounts held at IAP after they've been terminated. And they also found evidence, and this is in the record, that they had misrepresented and they actually failed to disclose conflicts of interest in their Form ADV to customers. And as our expert testified, that failure to disclose that they were duly registered with both IAP and their new firm constituted sufficient allegation of misrepresentation. And then with respect to selling away, there's evidence in there that defendants found that plaintiffs had executed transactions on behalf of customers of IAP through Apex while they were still registered as with IAP. In other words, that they were selling away. And then if we look at the step 3, even if the court didn't need to look at defendant's evidence in the step 2 process, certainly if the court had engaged in step 3 as required by the TPPA, they would have needed to look at the evidence that defendants brought to bear regarding truth of the allegations and with regarding to their good faith in making the statements. In other words, that they believed those statements to be true. In addition, there were 2 other reasons. One was that there was 2 other valid defenses. One was qualified public interest defense. And then if you look at the Pate against service merchandise, they found that a privilege exists even if the defamatory matter is false, so long as there's an initial requirement to report the matter to a public officer or private citizen who could have taken action, if true. And here, they undeniably made these statements within the FINRA context, regulatory context to regulators who could have taken action on this.
Excuse me for interrupting, counsel. Did the trial court make any specific findings of fact with reference to the defenses?
It did not. The trial court did not engage at any point and this was all in the papers. There was no testimony. The trial court did not make any engage in this third prong at all.
As I understand, part of the appellee's argument that there were implicit findings. Could you address that, please?
Well, actually, if you look at the Reese case, there is that we've cited, there is that in that case, the Tennessee Court of Appeals found that against looking into any implicit findings by a court. If the court didn't put them on paper, that was a basis for overturning their decision under the TPPA. The court needed to show its work on that.
So what relief is your client seeking with reference to that aspect of this argument, if there were no findings of fact or conclusions of law?
Well, we would find, to begin with, that it should be reversed because there is on the record sufficient evidence to show that these were true statements. And if there's not enough, and if the Court of Appeals doesn't want to do the work of the circuit court on this, then to overturn that decision to send back to the court to make findings.
Thank you.
Thank you.
Good morning, Your Honors. Don Aho of the Chattanooga Bar, appearing on behalf of the appellees, Mr. Robert Pragnell, Mr. Jonathan Emanuel, Mr. William Wood, and Mr. Christopher Taylor. This case presents important issues requiring the interpretation of the Tennessee Public Participation Act as it relates to mandatory disclosures required to be made on Form U-5, which is titled the Uniform Termination Notice for Securities Industry Regulation. Appellant's completion of these forms, as Judge Davis has pointed out, is at the heart of this dispute. There's no dispute that the form has to be completed accurately, thoroughly, and timely. In fact, appellant's expert even said that in his report. And as we look at the documents that opposing counsel have cited here, and as they relate to those U-5s, we think that the statement by the appellee's expert as to what this case is about and how those U-5 forms relate to it and why they're relevant, all of those forms are relevant, is where Mr. Scales, appellee's expert, said this is a textbook case of Form U-5 being used to harm advisors departing from an advisory firm. The critical issue we submit that's presented by this appeal, Your Honors, is that the trial court erred when it found that the petition was not frivolous or filed solely for purposes of delay. The evidence in the record demonstrates that the petition constitutes a serious abuse of the TPPA that has required appellees to unnecessarily incur great cost, expense, and delay to defeat the petition in the trial court and now in this court just so they can proceed to trial. This court should reverse the trial court's finding that the petition was not frivolous because the evidence proves that the petition was both frivolous and filed solely for purpose of delay. We note that the TPPA specifically allows the courts to find that a petition under the Act is frivolous or filed solely for purpose of delay, but it does not provide guidance on how the court should make that finding. Therefore, we've got to look to well-established principles of common law, which tell us that as a matter of law, a legal claim, or appeal for that matter, is frivolous if it is devoid of merit or has no reasonable chance of succeeding. The trial court erred when it found that looking at the facts stated in Mr. Franklin's affidavit on their face, it can be said that the statements on the amended Form U-5 were not intentional or reckless falsehoods. This finding was erroneous because the court did not consider whether the statements were made with negligence and failing to consider whether the statements or ascertain the truth of the statements. But it was also erroneous because the fact that the statements were false and the petition was void of merit was shown in the appellant's own evidence in Mr. Franklin's affidavit and those U-5s. As a matter of fact, the court need look no further than Mr. Franklin's affidavit and the Form U-5s to find that he falsified the U-5s. Franklin's affidavit specifically says that prior to late June 2020, appellants opened an investigation into appellee's conduct. Franklin also makes clear in his affidavit that the investigation that he claims was conducted occurred both before and after the appellees left in late June of 2020. And so if the court looks at that in light of his affidavit, at the form in light of his affidavit, he says there that regarding the investigation, that he knew by late June 2020 that appellees had engaged in violations of IAP policies and SEC and FINRA rules and regulations, and from that point, before the appellees left in late June of 2020, that appellees needed to be terminated. And that's at page 159 of the record, Your Honors. After he supposedly made these investigative findings, he says then that appellees were terminated on June 25, 29, and 30. But despite admitting that the appellees had violated, that he knew that they violated IEP policies and the SEC rules, he falsely stated on the form that they left the firm voluntarily. Now, Mr. Ward says in the complaint that they did leave voluntarily, and they ended up leaving voluntarily, but the point that we've made clear in the briefing and the record now shows is that they didn't leave voluntarily when Mr. Franklin said they did. He says that he terminated them, when in fact, if that's true, then he filed a false form, U-5, because it wasn't voluntary, even by his own admission. Thus, even though the plaintiffs admit that they were obligated to make mandatory disclosures on the form as accurate, thorough, and timely as possible, That document shows on its face, the original U-5s, that he filed a false statement on those forms. We next look at the amended U-5s in light of Franklin's affidavit. And when we do so, the fact that jumps out is that that amendment is false on its face because it is factually impossible to say in January of 2021, 6 months after the appellees have left, that they were terminated in July or late June of 2020 for misconduct. You can't square those. They're factually inconsistent, and that makes both of those documents false on their face. But there's even more, Your Honors. The amended U-5 state that the amended reasons for termination were initially suspected, but not certain. Ongoing investigation has provided confirmation that the full scope has not yet been determined. That's at page 84 of the record. But Franklin's affidavit proves that this is a false statement because he's already said before they left, because of this investigation that they conducted, that plaintiffs had engaged in violations of IEP's policies and SEC and FINRA rules and regulations, and he knew they had to be terminated at that point. And there's even more, Your Honors. And though Franklin stated in his sworn affidavit that this investigation had been conducted even before the appellees left in June of 2020, he makes another false statement on the amended U-5s, where he says that the date that the investigation started was not before they left, before they left, as he says in his affidavit, but exactly, he checks the box saying that the investigation act began exactly on June 25, 29, and 30, 2020, not before they left as he swore in his affidavit. So for purposes of determining that the petition was frivolous or filed only for purposes of delay, the evidence of the falsity of appellant statements in the U-5s is only the tip of the iceberg. The declarations of Mr. Pragnell and appellee's expert, Mr. Scales, state in detail how appellants violated industry rules and standards by improperly using and weaponizing the U-5s for the purpose of making false statements about appellees. And I'm glad Judge Davis referred to what I call the smoking gun email in this case, and that is Franklin's email of July 16, 2020. This email, which appellants make no effort to explain or even mention in any of their briefing in this court or the trial court, shows that the real reason why Franklin wanted to amend the U-5s was to attack and punish appellees for leaving IEP for Franklin's own competitive advantage. It is here in this email, Your Honors, that Franklin says in his own words, Robert is continuing to fight us moving forward, and if we continue to push back, we will look to amend his U-5 for terminating for cause. So this email is proof in Franklin's own words that he determined whether in his own words, what determined whether he amended the U-5s had nothing to do with any so-called regulatory violations, but everything to do with getting back at the four appellees for leaving his firm. So this email is also proof of other misrepresentations by the appellants, though they repeatedly state throughout their briefs that the appellant's big sin requiring their termination was being dual registered with investment advisory partners and their new firm, Apex, which Mr. Franklin was completely aware that the appellants had, or the appellees had formed. If the court looks at that document, which is at page 418 of the record, it will see where Mr. Franklin has listed all these reasons for termination, right? But one reason for termination that they talked to throughout their briefing about dual registration is not even mentioned there. So what's happened here is that the appellants have had to change their story at different points in this lawsuit. And when the court looks at the appellate record and their briefing, they now are relying not on the fact or the claim that the factual information contained in the Form U-5s was accurate, and that my clients had engaged in misrepresentation, selling away, or a violation of clients' privacy rights. What they're saying now is that they just suspected it. So they've changed their story here, and we believe that all of the evidence only leads to one conclusion, and that the appellant's petition had no chance for success. And to your question, Judge Frierson, about no reference to the defenses and the implicit finding by Judge Hollingsworth that the defenses had no merit, I would refer the court to Judge Hollingsworth's opinion. He found, based on the record, and in particular the email that Judge Davis referred to at 418 of the record, that the appellants had shown, based on that email, which he quotes from at pages and refers to at page 747 and 748, that what the appellees had done was to make a prima facie case that the defendants intentionally published false statements about them that caused them actual harm. I mean, and this again goes to the frivolousness claim that we're making here, because Mr. Franklin knew that that email existed before he filed that petition. And our position is that, knowing that, he should have known, to your point, Judge Davis, when the trial court saw that, is that not in and of itself sufficient evidence to defeat this petition under the standards that apply here? And with regard to your question, Judge Frierson, about the need for remand, there's no need for remand here. This is all on a paper record, just like with a summary judgment. This court should decide step 3 is our point. So, my time is up. Thank you.
Thank you.
Thank you, Your Honors. I would just point out to begin with that the email that Mr. Aho has been pointing to and that has been pointed out was voluntarily produced by my clients, despite the fact that there is a automatic stay created by the TPPA. So this was not something that was hidden by any regards, and certainly quite the opposite, voluntarily produced. I do want to start out with, since Mr. Aho spent some time talking about their cross appeal for sanctions, I want to start by mentioning that in order to grant sanctions, the trial court had to find the defendant's TPPA position was frivolous or filed solely for the purpose of unnecessary delay. Here, the circuit court expressly found it was not frivolous or filed for delay, and even if it had made such a finding, costs and fees for the party opposing the position would still be discretionary. The court may award them pursuant to Section 107B. And that's in direct contrast to fees and costs against plaintiffs, which are mandatory under 107A if the petition is granted. And so the standard here would be abuse of discretion, and the circuit court here correctly found defendants had established their prima facie case for the TPA protection. So they found a prima facie case basis for this matter, and indeed, the TPPA should have been granted. I want to also address what has been focused on here. An argument has been two things: the voluntary or involuntary nature of this of the disclosure, and again, that's a red herring because that's not something that was. There's no basis for that under the complaint. There's no complaint about whether they were voluntary or not, or any statement that they were incorrectly noted as voluntary. And in fact, what I heard here was that it was correct to be voluntary because they were voluntary, but just at a different time. I don't understand how that works. Once you're terminated, you can't voluntarily leave. It's involuntary at that point. There's no later time to be voluntarily leave. You can't say, you can't fire me because I quit. And then
Well, didn't your client create that issue, though, by providing two completely different U-5 forms that say basically two different versions of how the departure took place?
Well, if it's voluntary, then that, as they mentioned in the amended disclosure, they say that they initially suspected, but couldn't confirm that at the time, and so they had subsequent. And if you look at the declaration by Mr. Franklin and by the expert, they showed that there was an investigation that took place subsequently after they suspected these issues that they did know about with dual registration. And then they subsequently looked into this and found additional information to then find that they could confirm this. And that was something that was directly on that amended disclosure, that it was suspected but not confirmed. And I also just want to, I also want to.
Well, I'll let you complete that
Okay.
point since there was a question asked. Go ahead, just complete the point you got.
Okay, thank you. The other thing, other than this voluntary, involuntary red herring, is motivation. That they say that correctly there is an issue with this email. Well, but that does not go towards malice, which needs to show that there was some understanding that this was incorrect. So what they haven't talked about is the accuracy of these statements. Of these three things, is there support for them? And we have shown under the record there's support for each of these actual statements of violations of the misrepresentations. And we have cited into the record where we have found evidence of the misrepresentations, the violation of client privacy, and the selling away. That's what's at issue here.
Thank you very much, sir. I want to thank the attorneys for your presentation. Your case has now been submitted to this court. You should receive our opinion and decision within a week. Thank you both. It's good seeing you, sir.